how the fuck is this supposed to be read? I believe he got the DVRO because Bree released his phone number and stuff. Yeah, and they kept saying, I bet you it's going to get completely granted. I bet it's going to get granted that she can't post the baby. Yeah, because this is also about posting the baby. Because remember, so it says, did it bring up the, okay, good. Yeah. The court acknowledges the court is not inclined to make any orders at this time related to the sharing of content about the minor child, including via live stream, social media, by either party. Where is it at? Whoa, that went fast. I believe, and threatened to burn his barbershop down. That's crazy. That's a little crazy. Okay, right here. The court finds that this case raises First Amendment issues. The court orders counsel for each party to file and serve briefs addressing the legal issues, including the First Amendment issues related to petitioner's request for domestic violence restraining orders. Such briefing should discuss the legally permissible parameters, if any, regarding the issuance of restraining orders related to a party's social media post, including but not limited to comments made by a party on social media about the minor child or the other party. So it's about, he's basically just trying to say, I don't want you talking about either of us. I don't think she meant to tell it and it slipped out. Bad slip. Factual and procedural background. Evil Sizer and Sweeney were married in November 2010. Evil Sizer used 2 phones during her marriage to Sweeney, one for the legal side of her business and another for the management side. I don't know what that means. Of her business that she also allowed her young son from a previous relationship to use for playing games. Sweeney claimed that he had regular access to both phones for the purpose of taking pictures, sending email, text messages, browsing the internet, or using applications, and that the phones were not password protected. He also claimed that Evil Sizer gave him the password to her email account so that he could send emails for her and have full access to her email. Evil Sizer disputed these claims. Are these new docs? The ones I just had up are from the 6. They're the newest ones, yes. And this right here, we're going over something different. This is the case that's referenced for their First Amendment thing that's coming up in July. So, Evil Sizer gave birth to the couple's daughter in November 2012. Around this time, Sweeney became concerned that he might not be the child's biological father. Oh no. After he read a text message on his stepson's phone leading him to believe that Evil Sizer had received fertility treatments without his knowledge. He then downloaded the contents of Evil Sizer's phone using software that made it easier to read the information. Oh, he sounds like a creep. Sweeney obtained tens of thousands of text messages from the phones as well as information from the notes section of Evil Sizer's phone, which Evil Sizer used as a diary. He testified he thought it was unnecessary to get Evil Sizer's permission before downloading the data or to tell her he had done it after the fact because he had regular access to the phones and had previously backed up the phones to the computer. At her request, Evil Sizer denied ever asking Sweeney to back up data on her phones and denied knowing he had done so. Sweeney testified he downloaded the data at some point in late November or early December 2012. Evil Sizer testified that the date on the last text message obtained by Sweeney was on the night she gave birth to their daughter and that Sweeney had taken her phones from her while she was in labor. Sweeney ultimately spent about 20 to 30 hours reviewing the text messages he downloaded. In January or February 2013, he confronted Evil Sizer with information he had learned from her text messages. In March, he went uninvited to the home of Evil Sizer's parents and disclosed private and sensitive information about Evil Sizer to her father. Evil Sizer was very upset and shocked when she learned of the disclosure. The information Sweeney disclosed to Evil Sizer's father was personal and sensitive, but it was not information Sweeney had learned from downloaded text messages. At oral argument in this court, Sweeney faulted the trial court to the extent it relied on incidents where his behavior... Aw, Shelby! Hey! How are you? Thank you for the heart me. Where was I? It relied on incidents where his behavior was supposedly unrelated to his downloading of information from Evil Sizer's phone. We consider the evidence probative of whether Sweeney was prone to disclosing extremely... Oh, Santos is live. Ugh. Surprised he didn't show his face in here. Sweeney was prone to disclosing extremely sensitive information about his estranged wife, whatever the source of information was. That month, the parties separated and dissolution proceedings were soon initiated. Disputes arose over various issues, and the trial court has characterized this as a highly contentious case. One such dispute was over child and spousal support, as well as the sharing of costs for a custody evaluation. On August 30th, 2013, Evil Sizer filed a request to increase Sweeney's support payments on the ground that her income had decreased because her father had fired her from her job with the father's company. In opposing this request, Sweeney alleged that Evil Sizer had colluded with her parents to falsely make it appear she had been fired. Sweeney attached text messages to his declaration supporting his opposition. One was from October 2012, before the proceedings began, meant to demonstrate that Evil Sizer was misstating the assets of her disposal. Blah, blah, blah. Basically... Oh, wait, what is this? Part of the printout of the message that appears in the record is also illegible, and the text that is legible appears benign, at least when read out of context. Carrie, I'm on the train. What's up, girl? Imagine having your text read in freaking court, and it's like, what's up, girl? Okay, let's see if there's any... So... Basically, I'm trying to read it fast so I can summarize it for you because this is a lot. The court viewed communications as barely admissible and did not consider the subject central to this case at all. In response to her text messages being used as exhibits, Evil Sizer filed a request for a restraining order under the DVPA. She alleged that Sweeney had downloaded her private text to communications to third parties, including her attorney, without her consent, and had hacked into her Facebook account, changed her password, and rerouted the email associated with her Facebook account to his own. She claimed that as a result, she suffered extreme embarrassment, fear, and intimidation. She alleged that Sweeney threatened to reveal publicly more text messages and emails for leverage in the dissolution proceedings. She sought an order prohibiting Sweeney from further disseminating her text messages and emails, requiring Sweeney to return all electronically downloaded information he had accessed, along with hard copies of the message, and barring Sweeney from accessing or interfering with her internet service provider or social media accounts. Send me the clip. She's a bitch. Yes, definitely send it to me. So basically, this seems like it's just in a lot of reference to so here. People are all messaging me about Brie right now. At the time Evil Sizer sought and obtained the restraining order, the DVPA authorized a trial court to restrain any person for the purpose of preventing a reoccurrence of domestic violence and ensuring a period of separation of the persons involved if evidence showed reasonable proof of a past act or acts of abuse. A court may issue an order enjoining specific acts of abuse, which are defined as, among other things, behavior that could be enjoined under section blah, 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 blah. In turn, permits a court to enjoin a party from disengaging in various types of behavior, including disturbing the peace of the other party. The plain meaning of the phrase disturbing the peace of the other party may be properly understood as conduct that destroys the mental or emotional calm of the other party. The phrase includes destroying the mental or emotional calm of a former spouse by accessing, reading, and... Why is this like on here wrong? just joined. What are you reading? Everybody misses you, Shelby. We love you. So this is the case that they're referencing for Bree and 2K's court case that is coming up in July. And it seems like they'll be really talking about the DVRO stuff in July. That's mostly what July is about. And it's about, because this references the First Amendment, like they're referencing the First Amendment and then this stuff. This is the case. It's called Evil Sizer versus Sweeney. This is the case they keep referencing, meaning there's case law from it. In considering the evidence, we review an order granting a protective order under the DVPA for abuse discretion and in considering the evidence supporting such an order, the reviewing court must apply the substantial evidence standard of review, meaning whether on the entire record there is any substantial evidence contraindicated or contradicted. Contradicted or uncontradicted. Sorry, contraindicated is a nursing word. We must accept as true all evidence tending to establish correctness of the trial's courts. You think it'll go in his favor? It's kind of seeming like it. That's what I'm trying to get to. There's a lot. Yeah, it seems like it's basically talking about like doing all these things to mentally fuck with somebody, pretty much is what it seems like doing her using, because it has nothing to do with her being a social media person. It's basically saying like you can't use your platform to intimidate somebody, and like that's what this guy in this case seems like he was doing. Was he was downloading all her shit and like kept getting access to her emails and all this stuff to intimidate and scare her. So it seems like that's what it's kind of referencing. So the order provides that Sweeney may not take these actions except as otherwise authorized by the court, making clear that although Sweeney is not to use the material he obtained from Evil Sizer without her consent or knowledge, he may still seek the court's permission to use it for whatever purpose. So like basically saying like, yeah, you can't use all that stuff. Like, you know, you have it. He knows you have it. You can't say it out loud, but you can come to us and seek whatever permission. So like how she comes on and says she was abused or whatever. Oh, like I'm not supposed to say that word. It's supposed to be used. Like, you can't say that stuff anymore, but you could go to the court and bring it up in the court. It's not saying that you can never mention it again to them. It's just saying like you can't go online and do it, is what they would basically be saying. Oh, look, see, because it's like threatening. So he got to cross examine his ex wife in this. And it says, at oral argument, he highlighted his cross examination of Evil Sizer when he asked her whether he had disclosed text messages to anyone other than their custody evaluator. After Evil Sizer responded she did not know all the people whom he had supplied the text messages, Sweeney asked, have I contacted any of your third parties, whether it be friends, family, or associates? Evil Sizer responded, yes, you've written letters to them and you told them in your letters not to get involved or you would produce more text messages. So basically this person, that's literally what she does. So yeah, this won't go. I doubt seeing this go in her favor. This is more about her talking about them online and how it brings more drama and harm to everything. Interesting. That is interesting. Huh. Do y'all like when I pull the stuff up on the screen and everything for y'all? I mean, if y'all prefer me to just talk about it, I can, but I figured y'all liked when I brought it up. I figured that was a plus. Good. Good, good. And I'll be paying attention if there's anything new. We should be getting like evidence and stuff coming in July, like 18th ish. So we should be seeing some stuff. Oh, y'all, I'm tired tonight. It's only 10:30 and I've been going to bed at like 2 a.m. Don't forget, we're going to have our pride party to celebrate reaching our sub goal. We'll do that Friday. It's at 10 p.m. Hey, Ashley. We will be I'm trying to think. I don't know what we're going to stream tomorrow. Y'all tag me in all the things. After that crash out, I have a feeling we'll have some more drama to talk about. I'm still staying in contact with Alan and trying to talk to him about some things. Going forward, maybe a little follow-up interview to see if he has made any progress on getting any of his stuff, because me and a couple people advised him. Oh, Valet had a little crash out. Hold on, my Peppa's waking up. She's making a face at me. She keeps wanting to not nap during the day because, oh, sorry, I'm looking at my baby back there. Oh, it is weird. It does kind of just look like I'm looking at the computer. Oh crap, I forgot what I was gonna say now. I forget it. You didn't miss too much. We were just kind of rambling tonight. We went over the case that, oh, Enzo likes carrots. Thank you. My son is going through the same stage. No naps. Yep. It's the worst. She is just like in some weird, yes, I like our naps. She just wants to party with the rest of them.